Now, let's move on to the keynote speech. Senior Associate Justice Marvic MVF Leonen is one of the youngest justices to be appointed in the Supreme Court. In 2022, he marked a decade of service on the bench. And even before passing the bar, he has been deeply involved in social-civic cases. After his graduation from law school, he immediately founded a public interest group dedicated to assisting indigenous peoples and upland rural communities. He also joined the Free Legal Assistance Group and co-founded other alternative law groups. Prior to his stint in the judiciary, he was the Dean of the University of the Philippines College of Law. And at present, Saj Leonen leads several committees in the Supreme Court, including the Committee on Sustainability and Environmental Concerns. Ladies and gentlemen, Saj Marvic MVF Leonen.
Maraming salamat. Magsiupo po tayo. Let's all sit down. The beloved Dean of the University of the College of Law of the Philippines and the University of the Philippines, Dean Darlene Marie B. Berberabe, the Honorable Richard Palpalatok, the Chair of the Commission on Human Rights, Dr. Ivano Alogna, the Research Leader in Environment and Climate Change Law of BIICL. Thank you for that very comprehensive presentation of a very useful platform. My good friend, Attorney Tony Oposa Jr., the President of the Law and Nature of Nature Foundation, the Honorable Judge Lady Ivy Vanity Velasco, the MTC Judge at Large, who is now here present, Dr. Laura David, Director of the UP Marine Sciences Institute, Dr. Robert Michael Di Filippo, Assistant Professor of the UP MIGS, Ms. Briones Iales, Team Leader of the Asian Development Bank Environment and Climate Change Judicial Capacity Building, with whom the Supreme Court has had many engagements. Hafizul Islam Khan, Advocate of the Supreme Court of Bangladesh, Mr. Derev Sano, Executive Director, Greenpeace, Southeast Asia. My good friend, Attorney Griselda Mayo Anda, Executive Director of ELAC, the Honorable Jesus Torres, Municipal Trial Court Judge at Large, Shri Ritwik Duta, Managing Trustee, Legal Initiative for Forest and Economics, Attorney Gregorio Rafael Bueta, Faculty Member of the Ateneo de Manila School of Law, the other law school, Attorney Ryan Rosette, Coordinator of the Direct Legal Service, Legal Rights and Natural Resources Center, kasama sa Kalikasan, Friends of the Earth, Philippines. Attorney Mai Asaoka, President and CEO of the Kiko Network. A while ago, there was an acknowledgement of, I think, Angie from the Philippine Holding Corporation. My good friends from the UP College of Law and the Law Center, Professor Romel Cassis, Professor Michael Chu, the head of the IPD. Professor Romel heads the International Law Institute of the Law Center. I hope I got that correct. He is also the coach of the world champions of Jesup and Stetson. Professor Jackie Espinilla, now director of the IMLOS, not yet. I'm promoting you, and I'm also promoting you to director of another institute. But Professor Jackie is also, I think, the chair of the International Law Department of the Philippine Judicial Academy. I make sure that there are lots of UP people there. Attorney Raymond Bagilat, and of course, Professor Donna Sapa Gasgonia, who now teaches a core subject and from a very progressive perspective. Professor Donna and I go a long way back. Professor Donna conceptualized the concept of ancestral land and ancestral domain through Dao 2. Anyway, that's for the students to find out. In the new case of Republic versus NCIP, which I had the privilege to pen. Thank you for your kindness and your invitation in providing me with a platform today. In a different lifetime, I was an advocate of indigenous peoples, upland rural migrants, and the environment. And at one point, I was vice chair of Friends of the Earth International. So forgive me if today, to give you, as a part of the honor that you have given me, that I will sound a bit more critical because we have a long way to go. Environmental law's most significant hurdle in our jurisdiction has been a persistent question of what Habermas calls legitimacy as facticity. Internationally, foundational principles of environmental law are often classified as soft law or aspirational. In our jurisdiction, that hated word of mine, hortatory. Victories in other jurisdictions have yet to be adopted within our legal system. Our country's National Report on Corporate Climate Litigation, I think written by a team led by Professor Mike Chu, which is the focus of today's activities, recognizes that attempts to hold the corporations liable for climate change still lack very definite causes of actions defined by jurisprudence. Consequently, we have had to resort to correlating environmental rights with more developed legal disciplines, such as tort, law, and human rights. Multiple factors contribute to the gap between environmental law and their effective enforcement. Our society's focus on the vicious cycle of production and consumption stunts our imagination. Our laws and how we interpret them can better represent the urgency of climate change, environmental protection, and importantly, along with all of this, community empowerment, identity recognition, together with sustainable development. There have been attempts to bridge this gap, as seen in the legal developments, recognizing the constitutional right to a balanced and healthful ecology. However, for these developments to achieve their intended purpose, their application requires rigorous preparation when advocating for public interest, including environmental cases. Effective representation requires responsible, deliberate, and calculated preparation. Representation must also be anchored on the real interests of communities, sectors, and identities, especially in a situation where we suffer from inequality and disempowerment. Our rules must respond to our society's evolving needs and keep pace with emerging threats. We recognize the critical work that needs to be done to enhance our environmental and community practices further. We must continue to ensure accountability in addressing climate change and environmental harm. As I speak, and as part of the judiciary's strategic plan for judicial innovation, or what we have called the SPJI, our team collates the inputs of several focus group discussions regarding possible reflections and amendments to the current environmental rules. We have also published a notice inviting all to share their thoughts through position papers sent to a dedicated email address. And kindly take note of this, it is easy to memorize, kalikasan@judiciary.gov.ph. kalikasan@judiciary.gov.ph. I will test you with respect to the email address later. I invite all of you to participate. In October of this year, we will be staging the National Judicial Summit on Ecological Sustainability and Climate Change, the first of its kind. There, we will discuss proposed amendments to the environmental rules coming from different focus group discussions, from NGOs to practitioners to judges and even from the business sector, and the challenges that the current judiciary faces. Today, however, I expound on some points to trigger your reflection. These are not all the points that you should be concerned with, especially with respect to slums, but these are the points which I think can be very controversial. One, the concept of legal standing in environmental cases. Two, the utility and the actual use of the precautionary principle as deployed in our courts. Third, the concept of environmental tort action as discussed in Sanggakala versus National Power Corporation. And fourth, the revision of the rules of procedure for environmental cases particularly the adequacy of the protective writs of kalikasan and the concept of forever continuing mandamus to compel corporations to remediate any environmental damage caused. On legal standing in environmental cases. The rules of procedure for environmental cases allow any Filipino citizen in representation of others, including minors or generations yet unborn, close quote, to bring a citizen suit to enforce the rights and obligations under environmental law. In Arrigo versus Swift, I warn against using future generations' rights to litigate present disputes. First, they risk foreclosing arguments of those unable to participate in the suit, putting into question its representativeness. Second, varying interests may lead to political issues the court cannot resolve. And third, automatically permitting a class or citizen suit on behalf of, quote, minors and generations yet unborn, close quote, may oversimplify a complex issue of representation, especially when future generations' true interests on matters are yet to be determined. It is good drama, but it is not very accurate. The Supreme Court's rulings can bind future generations. Mistaken use of the remedy by putative representatives may diminish the future generations' ability to decide for themselves and may eventually harm their interests. It is, in fact, disempowering. In the same opinion, I suggested reviewing Oposa versus Factoran, that doctrine indiscriminately allowing the present generation to assume for itself the autonomy of those who will exist at a different time under a different set of circumstances, thus preventing future generations from protecting their own rights and pursuing their own interests and decisions. As a middle way, I suggested invoking the legal standing of generations yet unborn only under the following circumstances. First, there is a clear legal basis for the representative suit. Second, there are actual concerns based squarely upon an existing legal right. Third, there is no possibility of any countervailing interests existing within the population represented or those that are yet to be born. And fourth, there is an absolute necessity for such standing because there is a threat of catastrophe so imminent that an immediate protective measure is necessary. Short of a nuclear war, these requirements would not be met. As a better solution, cases must be brought not in the name of our children or those yet unborn. They will be able to speak for themselves. We should bring cases that we ourselves represent. We care for the next generation, but we should always acknowledge that we cannot pretend to speak for all of them and for the next generation. The same risks that arise from irresponsibly invoking the rulings were palpable in Resident Marine Mammals versus Secretary Reyes. The human petitioners sought judicial notice of the identity of interest between them and resident marine mammals. Although the human petitioners forwarded the noble cause, the space for legal creativity required to advocate for issues of public interest is limited. Abuse will be the offshoot of making legal standing more liberal. It stunts the development of serious and competent advocacy for media copy. And the Supreme Court rightly did not allow the petitioners to anthropomorphize the issue of ecology. To emphasize, Oposa and the attempt in resident mammals should be invoked indiscriminately. Citing these cases to justify environmental claims can diminish the value of legitimate environmental rights. It may run the risk of allowing petitions based on concern rather than an actual enforcement of an actual right. We should not risk undermining a noble cause when reasonable, cogent, rational, scientific, well-founded arguments can be made. Any kind of class suit comes with a great responsibility for skill, competence, knowledge, and let me add, humility. the utility of the precautionary principle. The precautionary principle, as currently stated in the rules, guides court action when there is lack of full scientific certainty establishing a causal link between a human activity and an environmental effect. There are 2 points. Lack of full scientific certainty, which means that there can be some certainty, and causal link. Reflecting Principle 15 of the Rio Declaration, when there is a threat of serious and irreversible damage, the lack of full scientific certainty should not postpone cost-effective measures to prevent environmental degradation. I emphasize from the quote, cost-effective measures to prevent environmental degradation. The standards for invoking the precautionary principle should be refined in jurisprudence and in our courses to guide advocates, regulators, and adjudicators. De la Cruz versus Manila Electric Company appreciated the scientific basis for regulating human activities affecting people's right to a balanced and healthful ecology. In De la Cruz, several subdivision residents sought to enjoin the construction of high-power electric lines by simply invoking the precautionary principle and nothing else. We ruled that the precautionary principle did not apply because scientific studies existed to establish how current regulations mitigated the health effects of high-frequency electromagnetic fields on human beings, or scientific studies also existed on how they were insufficient. In litigation, the precautionary principle is not a substitute for an in-depth survey of relevant scientific literature by the advocate. Being able to do science is an integral part of environmental litigations. And may I repeat, being able to do some science is an integral part of environmental litigation. De la Cruz cited the discussion in Mosqueda versus Filipino Banana Growers and Exporters Association, Incorporated, that invoking the precautionary principle does not suspend judicial rules on evidence, reason, and legal interpretation. In Mosqueda, a city ordinance prohibited the aerial spraying of pesticides within Davao City. The court declared the ordinance unconstitutional, discussing that precaution as a risk management principle applies only after some causal basis is shown linking the alleged environmental harm and the activity being prevented. I quote from the decision. Precaution is a risk management principle invoked after scientific inquiry takes place. This scientific stage is often considered synonymous with risk assessment. As such, resort to the principle shall not be based on anxiety or emotion, but from a rational decision rule based in ethics. As much as possible, a complete and objective scientific evaluation of the risk to the environment or health should be conducted and made available to decision makers for them to choose the most appropriate course of action. My opinion in Mosqueda qualified the need for a scientific basis as a full prerequisite for invoking the precautionary principle. Restricting activities out of unfounded precaution does not make sense if it is not accompanied with any proof of causation. In my view, causation was important, not full scientific basis. Contrary to how it has been deployed in the past, the precautionary principle calls for a more precise, reasoned, and deliberate approach to environmental advocacy and regulation. The principle was never meant to forbid any beneficial activity simply because all human activity could actually impact on our environment. Just because we live, we have an impact on our environment. The right to a balanced and healthful ecology will be meaningfully upheld only if we can maximize regulated activities' social and economic benefits and ensure their just impact while minimizing environmental costs. Again, all this requires skill, expertise, and meaningful perspective. This conference attests to its importance as it shares a global toolbox. Fourth, the concept of environmental tort action. In addition to regulatory measures, environmental tort action provides another crucial legal mechanism for addressing ecological harm if there is personal injury to an individual, a group, or a community, or even an identity. Environmental tort action introduced by your Supreme Court in Sanggakala versus National Power Corporation allows individuals or groups of individuals to seek redress for damages caused by environmental pollution or degradation. These actions are grounded in traditional tort principles of negligence and nuisance, but adapted to address the unique challenges posed by environmental concerns. In Sanggakala, petitioners were farmers and fish pond owners along Lake Lanao. They filed separate complaints for damages against the National Power Corporation due to its refusal to open the floodgates of the Agus Regulation Dam whenever there was flooding. They alleged that the flood damaged their farmlands and crops in various years from 1979 to 1996. The duty of the National Power Corporation in this case was based on a 1973 Memorandum Order Number 398, issued by the Office of the President to preserve the Lake Lanao watershed and to install markers in every town around the lake, indicating the cultivation of land below 702 meters elevation. The petitioners argued that the National Power Corporation had a duty to warn residents about this risk. In seeking the dismissal of the petition, the NPC countered that there was no direct causal connection between the construction of the Agus Regulation Dam and the damages the petitioners allegedly suffered. It claimed that the damage was not an actionable wrong. For them, it was damnum absque injuria, or damage without legal injury. In finding Napocor liable for environmental tort based on negligence, Sanggakala leveraged the overlap between the goals of tort law and environmental law. Ecological laws focus on correcting or preventing environmental harm to many. Tort law is concerned with correcting wrongs caused by another's fault or negligence on another. Sanggakala bridged the gap between harm and liability by defining harm in an environmental context and holding the actor accountable for tortious negligence. In Sanggakala, an environmental harm was defined as immediate and future physical injury to people, emotional distress from fear of future injury, social and economic disruption, remediation costs, property damage, ecological damage, and regulatory harms. We then reflected on the definition and explanation of the cause of action in an environmental tort. Structuring the analysis of liability for environmental harm around the concept of civil tort liability recognizes the importance of the rules on torts in addressing harm to both individuals and the environment. We explored negligence as a critical element in environmental tort cases, noting that such action succeeded when actual injury to a person, group, or property is proven. The primary aim of an ecological tort action is to deliver corrective justice by assessing the relative fault of the responsible party, often a corporation, for a harm caused to another. The relationship between tort law and environmental law will be better developed with the cases that you may all intend to file in the future. The intricacies of environmental protection require deep discernment by both advocates and judges, which we attain only through studying current and emerging concepts in environmental law, science, and philosophy. With further refinement, environmental tort will be an excellent instrument for addressing environmental harm and climate change through its continued usage in the appropriate cases, now that we still do not have a particular law on climate change responsibilities. The adequacy of writs of kalikasan and continuing mandamus. Past jurisprudence reflects the tendency to forego discernment and deliberation when claiming relief through our environmental rules. Recourse to these remedies often sacrifices diligence for expeditiousness. As past applications for the issuance of writs of kalikasan would show, quick action is useless when it fails to secure the needed remedy. In Pahe versus Casino, we declined to issue a writ of kalikasan because the petitioners failed to substantiate their need. Moreover, the petitioners' failure to support their claims of environmental harm bordered on, as the court said, trifling with court processes and merited their admonishment. I reiterated the need for responsibility and accountability in environmental advocacy in a separate opinion, mainly because of the technical nature of environmental cases. Referencing Arrigo versus Swift, I emphasized that environmental advocates must be capable of bringing reasonably cogent, rational, scientific, well-founded arguments as a matter of fairness to those they say they represent. Whether these incidents result from a discrepancy on the rules or an overzealousness in advocacy, it is still worth noting that the judiciary itself desires to protect the environment, even with cases that may have had only prima facie lack discernment. In West Tower Condominium Corporation versus First Philippine Industrial Corporation, I dissented from the majority because they insisted on enforcing the writ of kalikasan beyond its intended bounds. In that case, the majority asked the Department of Energy and the respondent to repeat previous procedures, implying that the court doubts the executive's ability to deliver on their commitment. There, I noted that the court should stay true to the separation of powers and not bestow upon itself expertise and resources to check on administrative agencies' technical conclusions without basis. The same overzealousness informs my reservations about the scope and bounds of judicial action when enforcing a writ of continuing mandamus. In Abines versus Duque, we explained that the limitation of the writ must be based on judicially verifiable parameters within a specific period. Judicially verifiable parameters within a specific period, not forever. Dahil walang forever. This period should be grounded on empirical proof and reasonable scientific grounds. I suggested that every petition for a writ of continuing mandamus should allege three things. First, serious and systematic inability of the respondent executive to meet their constitutional or statutory obligations to protect and preserve the environment despite repeated demands. Second, convincing circumstances that the non-issuance of the writ will result to irreparable damage to our ecology within the scope provided in our rules. And irreparable has already been defined by our court. Third, specific, measurable, attainable, realistic, and time-bound objectives that have rational relation to the irreparable damage sought to be avoided. This is yet to be adopted and hopefully could become part of the amendment to our environmental rules. There are evident gaps in the rules and remedies in environmental cases that must be addressed through a collaborative effort from the courts and the advocates who assert rights before them. I call the respondents, corporation and government, also as advocates because I have seen some of them with very kind intentions. The avenues for relief under the special writs are admittedly narrow, as judicial intervention is meant to be exercised with restraint, but this does not mean that they are impossible. Hopefully, these gaps can be addressed as we review our environmental rules, discuss the same during the National Summit. It will be addressed as you strengthen your advocacies and work more with our communities. In this light, the court is also working to find support for social change and developmental lawyering. Organized public interest lawyers need support, and therefore they should not be made to depend only on the philanthropy of international organizations. Before I end, let me go to another uncomfortable topic, our lifestyles. Let us as well be accountable. We cannot be genuine advocates if all we ask is others to change their behavior. In the book, This is Vegan Propaganda and Other Lies the Meat Industry Tells You, Ed Winters talks about the abhorrent practices of the meat industry and its detrimental effects on the most significant issues in the world today, namely climate crisis, infectious and chronic diseases, and human and non-human exploitation. He does this not to condemn, but to give everyone an avenue to make an informed choice. Significant in today's world is Chapter 4 of that book, which tackles avenues in which we can protect the planet and save our environment. The livestock industry is one of the top 2 or 3 contributors to the most severe environmental problems at a global level. The sheer amount of land used for animal agriculture is staggering. The United Nations reports that 26% of the planet's land surface is used for grazing. It is important to stress that these grazing areas are not natural, but man-made or human-made recreations of landscapes that have been altered or eradicated to make room for herds of what Winters calls sentient beings. Due to deforestation, hundreds of thousands of species have lost their habitat. For example, 56% of species have fallen in the United Kingdom since 1970, and with 25% of mammals and 50% of all birds facing extinction. The University of Oxford also determined that while livestock production uses 83% of agricultural land worldwide, it only supplies 37% of the world's protein and 18% of its calories. This exemplifies the inefficiency of the animal agriculture sector. In a nutshell, the benefits we reap from the consumption of animal products are overweighed by the immense effort required to sustain it. Animal agriculture hurts the environment for many more reasons. Not only does it use vast amounts of land, but it also contributes significantly to greenhouse gas emissions. Carbon dioxide, which is produced through practices like deforestation, destruction of natural habitats, and damaging of soil. Methane, which is produced by the digestive system of ruminant animals through the process of enteric fermentation, and nitrous oxide, which comes primarily from manure and fertilizer use, are the most problematic greenhouse gases related to animal farming. The agriculture of animals is responsible for between 14.5 and 18% of world emissions. 14.5 to 18% of world emissions, according to recent studies. This means that animal agriculture accounts for more of the world's emissions than all forms of transportation combined. I repeat, animal agriculture amounts for more of the world's emissions than all forms of transportation combined. If more people adopt plant-based diets, approximately 75% of the world's farmland may become available. This would help farmers transition by increasing food production within their own countries and allow us to reforest, rewild, and restore enormous swaths of the natural world ravaged by human activity. In addition to eliminating one of the leading causes of global warming, switching to a plant-based diet is thus a powerful method to remove carbon dioxide. Restoring the natural world will enable us to sequester carbon. Be vegan, not because you want it for your health. Be vegan because of the political economy of it. By signing the Paris Climate Change Agreement in 2015, more than 190 countries made a legally binding commitment to limit global warming to far below 2 degrees Celsius above pre-industrial levels, aiming to keep it well below 1.5 degrees Celsius. A study from the University of Oxford found that even if all emissions from fossil fuels were eliminated immediately, the emissions from the agricultural sector alone would make it impossible to limit warming to 1.5 degrees Celsius and make it challenging to keep it below 2 degrees. I repeat, even if we stopped all fossil fuels, animal agriculture sector alone would make it impossible to limit warming to 1.5 degrees Celsius and make it challenging to keep it below 2 degrees. The same study found that to keep global temperature increase below 2 degrees Celsius, people in countries like the United Kingdom, the United States of America need to cut their consumption of beef, lamb, and pig flesh by 90%, and their consumption of poultry and milk by 60%, while simultaneously increasing their consumption of legumes by 500% and nuts and seeds by more than 400%. Proponents of regenerative animal farming and holistic management argue that animal grazing sequesters carbon back into the soil, improving biodiversity. The benefits are not sufficient to justify the cost. Carbon is stored in the bodies of grazing animals through photosynthesis. Grazing animals eat the grass on the pastures. After this, the plants are stimulated to develop again, and their roots may extend further into the soil, allowing them to sequester more carbon through photosynthesis. However, this also causes enteric fermentation, which releases greenhouse gas methane via the animal's belching. This carbon was initially consumed by the animal in the form of gas. Methane and nitrous oxide are produced as byproduct of cattle waste. Released into the atmosphere, the methane and nitrous oxide exacerbate global warming more than the carbon. Restoring biodiversity would be best accomplished by restoring natural habitats, especially forests, which can retain more carbon than pasture lands. Experts say that we are in a sixth mass extinction and on the brink of biological destruction, making preserving species and biodiversity among the most pressing challenges of our day. In addition to contributing to deforestation and greenhouse gas emissions, animal agriculture is a significant cause of soil erosion and water pollution due to fertilizer and manure runoff from grazing grounds. Millions of gallons of manure and trash are dumped illegally into rivers and waterways by meat processing farms. This eliminates aquatic life and promotes the growth of bacteria, poisoning the water supply of both animals and humans. Animal agriculture uses 35% of the world's fresh water because it requires more water to produce animal products than crop items. A meat-free diet can cut an individual's water consumption by as much as 58%, making the switch to a vegan diet a significant action towards reducing water usage. These adverse outcomes are not unique to grazing farmlands. There is mounting evidence that the fishing industry damages marine ecosystems and kills aquatic life. Carbon is released into the atmosphere when marine sediments are displaced due to fishing activities. In particular, bottom trawling fishing, where a big weighted net is dragged across the seafloor to collect fish, has been reported to produce as many as 1,500,000,000 metric tons of carbon dioxide annually. There are more emissions here than the entire aviation sector. One of the most effective things we can do to lessen our environmental footprint, that is if we want also to be accountable, is to adopt a plant-based diet. And a sustainable society must prioritize a food system based on plants and reducing food waste. It affords us the best chance to recover vast tracts of land that can be reforested, rewilded, and restored, thereby enhancing biodiversity, sequestering carbon, and significantly reducing water pollution, agricultural emissions, soil erosion, species extinction, habitat destruction, and deforestation. So my challenge to you is this. As we learn how to more effectively advocate in our courts, calling out the accountability of big corporations, should we not call ourselves out first? If we are genuine advocates, my question is, why are you still not vegan? An article published in Nature Sustainability, yes, I will repeat that. If we are genuine environmental advocates, answer me this. Why are you still not vegan? It is difficult because you want to taste steak. It is difficult because you want to taste lechon manok. But thinking more broadly, as you should because you are an environmental advocate and an advocate of social justice causes, why is it that you still maintain that diet. An article published in Nature Sustainability titled Earlier Collapse of Anthropomorphine Ecosystems Driven by Multiple Faster and Noisier Drivers aims to warn its readers that the destruction of our planet is not caused by any single cause, however. It points that most previous research has focused on just one cause of devastation, like global warming or forest clearances. However, when water stress, degradation, and river pollution from mining are added to the mix, collapse occurs considerably more rapidly. The team made up of academics from the universities of Southampton, Sheffield, and Bangor and Rothamsted Research investigated 2 lake ecosystems and 2 forest ecosystems, using computer models to see how multiple growing stresses from human activities, global warming, and more interactions between systems may abbreviate the time remaining before the world's ecosystems collapse. Through this, they discovered that even if a portion of an ecosystem is managed sustainably and kept constantly, new stresses such as global warming and extreme weather events can cause the ecosystem to collapse. In general, it was discovered that the systems are more vulnerable to collapse when their primary drivers are more powerful. Nevertheless, there may be synergy between the impacts of adding several drivers and adding noise on the onset of collapses. However, the significance of these shifts differs from system to system. The article proposes a more holistic approach, appreciating various factors influencing an ecosystem. It provides advocates with a valuable tool. Only thorough and deliberate analysis will yield the best outcomes possible by various developing approaches to environmental protection and sustainability. Refining these tools should coincide with honing our competencies. It is not who we sue alone. It is not what we do as lawyers alone, but what we also do as individuals, as families, as communities, and as groups. Environmental advocacy comes from a place of passion and compassion for our communities and our future generations. Advocacies cannot be fueled, however, by passion alone. Our people need more than just being able to speak and shout the loudest. Advocates should be responsible, diligent, and well-informed to be a more powerful voice of the oppressed. As I have taught various law classes in this college before, to be an advocate of a marginal cause requires more of you than being a lawyer for the status quo. We also need to live the lives that we demand of others. As before, and this year, I always end with a story by Elie Wiesel, a Holocaust survivor of Auschwitz. At a very young age, in a labor and cremation camp, the SS tortured his father. His father's last words were a plea for him to come to his aid. He lay where he was, scared that if he responded, he too would be killed. He survived, but with difficulty, and to expiate himself, he wrote a book entitled Night, and bearing witness, I read a paragraph. As long as one dissident is in prison, our freedom will not be true. As long as one child is hungry, our life will be filled with anguish and shame. What all these victims need above all is to know that they are not alone, that we are not forgetting them, that when their voices are stifled, we shall lend them ours, that while their freedom depends on ours, the quality of our own freedom depends on theirs. Close quote. Our people suffer. Our people suffer. We are privileged. We enjoy our titles. Under our watch, we cannot fail them. Thank you. Maraming salamat. Agyaman ak.
Thank you very much, Senior Associate Justice Leonen, for such a comprehensive and incisive discussion and critique of environment-related jurisprudence and even our diet and lifestyle.